Swayam Prabha. Digital India. Educated India.
Grant of patent subject to certain conditions. The grant of a patent is subject to certain conditions. The conditions are mentioned in 1, 2, 3 and 4 of section 47. Now, in the case of any machine, apparatus or other article in respect of which a patent is granted, or any article made by using a process in respect of which a patent is granted, may be imported or made on or behalf of the government for the purpose merely of its own use. So, the government has the power to import or make either by itself or on its behalf for its own use. If there is an invention and the government wants to use it, a patent can be done, the government can use it, and that is a condition on which a patent is granted. A patent is granted to any patentee in India on the condition that if the government wants to use it, you can't stop the government. 2. Any process in respect of which a patent is granted may be used by or on behalf of the government for the purpose merely of its own use. Now, 1 and 2 pertain to products and processes. 1 talks about products, product patents, whereas 2 separately talks about processes. 3. Any machine, apparatus or other article in respect of which the patent is granted, or any article made by use of the process in respect of which the patent is granted, may be made or used, and any process in respect of which the patent is granted may be made or used by any person. Now, this generally covers any product protected by a patent or any process protected by a patent for the purposes merely of experiment or research, including imparting of instructions to pupils. So, if patented product or a patented process is used for experiment or research, which includes imparting instructions to students, that is a condition subject to which patents are granted. So, patents are granted so that students can be instructed and taught, and experiments can be conducted on that field of technology, and as long as the activity pertains to experiment and research and imparting instructions to students, then that is a condition on which the patent is granted, meaning which by doing that you cannot claim that there is infringement, or it cannot be a cause for complaint by the patentee. 4. In the case of a patent in respect of medicine or drug, the medicine or drug may be imported by the government for purposes merely of its own use or for distribution in any dispensary, hospital or other medical institution maintained on or behalf of the government, or any other dispensary, hospital or other medical institution which the government may, having regard to public service that such dispensary, hospital or medical institution renders, specify in this behalf by notification in official gazette. Now, this allows patented products to be imported for government use either in government hospitals, dispensary or medical institutions, or those institutions, private institutions, dispensary, hospital or medical institution which the government notifies. Now, this is to cover instances where there is a break of an epidemic. There is a disease which affects hundreds and thousands of people. If the government wants to tackle that epidemic, like a viral fever, bird flu, avian flu or swine flu, then the government can import medicines and it can start giving out medicines to its citizens regardless of whether it is a private institution or a government hospital. In the case of private hospitals, the government needs to make a notification saying that in the light of a health emergency, these drugs will be available, though they are patented, will be available for. So, that is again a condition on which the patent is granted, which means if the government does this, there cannot be a cause for complaint by the patentee. 48. Rights of a patentee. Subject to other provisions contained in this Act, the conditions specified in section 47, we saw that a patent is granted based on certain conditions, that it can be used for research, it can be used for instructing pupils, it can be used for in hospitals, it can be used for by the government. These are the conditions on which by which a patent is granted. So, subject to those conditions, a patent granted under this Act shall confer on the patentee. There are two sets of right. A deals with rights with regard to a patented product, and B rights with regard to a patented process. Now, what are these rights? That the patentee has the exclusive right to prevent third parties. Now, this is the right granted by a patent. There is an exclusive right to prevent third parties from making, using, offering for sale, selling or importing. These are the 5 types of rights: manufacture, making, using, offering for sale, which is marketing, selling or importing. These 5 rights, the patentee has an exclusivity. So, he has an exclusive right to prevent third parties who do not have his consent. If they have their consent, it is called license. Now, B pertains to the subject matter of a patent is a process, the exclusive right to prevent third parties who do not have the consent from the act of using that process and from the act of using, offering for sale, selling, importing for those purposes the product obtained directly from that process in India. So, use of the process and use, offering for sale, selling or importing the product obtained by that process. So, it covers also the product that comes through a process. Now, in this case manufacturing is not mentioned, make is mentioned in the case of products, here make is not mentioned. There is a different provision because it is difficult to prove whether a particular process was used in the making of an product. If there is a process patent, it becomes difficult to prove, and that is the reason why you have this provision. Section 49. Patent rights not infringed when used on foreign vessels etc. temporarily or accidentally in India. This provision deals with instances where an equipment, more so in the form of a moving vehicle, that enters India, and it so happens that one of the components in that equipment or vehicle that comes into India is patented. Then just the fact that it came into India, and these are understood as vehicles that are in transit or equipment that comes into India in transit, it is not meant to be here, it is just for a temporary purpose. So, in such cases, even if the technology in that equipment or in that vehicle is patented, the coming into India and leaving the India, when it happens temporarily or accidentally, it does not amount to infringement. Now, this is the gist of the subsection. It covers various types of vehicles, like 49(1) deals with vessels, aircraft, land vehicle. Now, the fundamental premise of this provision is that what happens temporarily or accidentally cannot be the subject matter for an infringement, and this is done so knowing fully well that there will be new technologies that are used in aircrafts and vessels and land vehicles that could come into India and they could be a cause for infringement. But because they do not stay in India and they are not, if you could say that, commercially exploited in India, like there is no act of selling, there is no act of offering for sale, and there is no act of manufacture, it can be presumed that these acts are temporary, and because they are temporary in nature, they cannot be a ground for infringement action. 49(1) states that where a vessel or aircraft registered in a foreign country or a land vehicle owned by a person ordinarily resident in such country comes into India temporarily or accidentally only. Now comes into India, India includes the territorial waters also. When we mention India here, it includes the land and also the territorial waters. The sea surrounding the land to a particular extent is what we call the territorial waters. The rights conferred by a patent for an invention shall not be deemed to be infringed by use of the invention. So, if a vessel, an aircraft or a land vehicle which is owned by a foreigner, owned by a person ordinarily resident in a foreign country, comes into India and it happens that the coming into India is temporary or it is accidental, then the rights conferred by a patent for an invention shall not be deemed to be infringed by the use of that invention. Now assume that when the aircraft comes into India, there is a patent over a technology which forms a part of that aircraft, and that aircraft has a patent which is granted by the Indian Patent Office. Technically, the arrival of the aircraft into the Indian land would amount to infringement because there is an existing patent covering that piece of technology and the Indian Patent Office has granted a patent. Now, we want to exclude instances where one, it is hard to detect infringement, or the act of infringement is not a continuing act, it's just a stray act, or it just happens for a few hours, or it becomes difficult for us, or rather it causes inconvenience for us to do international travel and international trade, because it will be very hard for us to be in a situation where we start enforcing rights which could affect the way in which we communicate and the way in which we travel. Now let us look what are the instances. A, in the body of a vessel or in a machinery, tackle, apparatus or other accessories thereof, so far as the invention is used on board the vessel and for its actual needs only. So it is in the body of the vessel or machinery, tackle, apparatus or accessory, and the invention is used on board the vessel and for its actual needs. So it is a part of the vessel. B, in the construction or working of aircraft or land vehicle or of accessories thereof, as the case may be. So in the case of vessel, it should be a machinery or something which is a part of the vessel, which can be, the technology should be something which is actually used for the actual needs of the vessel. In case of aircraft and land vehicle, what is used in the construction or working of the aircraft or the land vehicle and of the accessories thereof. 2. This section shall not extend to vessels, aircrafts or land vehicles owned by persons ordinarily resident in a foreign country, the laws of which do not confer corresponding rights with respect to use of invention in vessels, aircrafts and land vehicles owned by persons ordinarily resident in India, while in ports or within the territorial waters of that foreign country or otherwise within the jurisdiction of its courts. Now this 49(2) incorporates the principle of reciprocity. India would normally honor rights of a foreign country which honors rights of Indians in that country. So this is the principle of reciprocity. So if that foreign country offers similar rights for Indians when they travel with their vessels, aircrafts and or land vehicles, then India would extend similar privilege for foreigners who would come into India using vessels, aircrafts and land vehicles. So this incorporates the principle of reciprocity, which is a principle in international law.